What is the procedure for jury selection in South Carolina? Hi, this is Dane Phillips, criminal defense lawyer in South Carolina. I'm here to answer these questions about criminal procedure and trials. Now, the question I received is, what is the actual process for jury selection? We have a very unique procedure in South Carolina when it comes to selecting juries, specifically as to the judge-run voir dire. Now, kind of starting from the beginning, as everybody knows, you'll get a summons in the mail from the clerk of court's office from the county where the trial is going to occur. And that gives you the date and time of when you're supposed to be there. If you don't show up, they actually could issue a bench warrant for your arrest or send a deputy to come pick you up and bring you to jury service. It's that serious. That public service component of it, that obligation, that duty is vital to the court system, to the criminal justice system. And it's certainly an awesome power to have that ability to be on a jury and to weigh credibility and ultimately make a decision about whether someone's guilty or not, whether the state has met their burden of proof beyond a reasonable doubt. But before I go too far into that, we'll be specific as to the question about jury selection. Now, what happens is once the jury pool shows up the court that morning, generally 9 o'clock is the time when they're supposed to show up to court. And ultimately what we call the fancy legal word of veneer is the jury pool. So you have everybody out there in that pool. And so what the judge is going to do is go through a set of questions, what we call the statutory type issues for qualification. And the judge is going to look, are there any reasons to disqualify jurors? Are there any reasons that a juror should be exempted? Are there any excuses there for a postponement or to transfer to another term of court? And so the judge will go through all these questions, and that takes generally an hour or two or more to go through and to figure out who was qualified. Do we have a qualified jury pool? And then once that is done, that is when the voir dire process happens. Now, what you see on TV a lot of times at other states is that the voir dire process can take days, weeks, incredible amount of time. Unfortunately for South Carolina, and something that good criminal defense attorneys are doing, are making motions for attorney-conducted voir dire. We have the fastest, at least based on a study I saw. So we can say at least one of the fastest, if not the fastest, voir dire process in the country. And that's not a good thing. That's not seeking fair and impartial jurors. And to explain that in detail is essentially the voir dire process is the questions that are presented to the potential jurors, and to find out what their known and unknown biases are, if there's implicit bias, to find out their prejudice, to really dig deep and figure out who these individuals are. So the only thing we're really provided is in a jury list. We get basically a packet. And so if you've ever been in jury selection, you see the attorneys carrying around this whole big pad of paper. All it says is the juror's name, that the number that's associated to them, say juror number 1, their name, their address, their occupation, their spouse and their occupation, and their age and their gender. Now, one of the things that lawyers can't do is strike a juror based on age or gender or race. And those are the things that we have. And what questions are presented is very limited, in my opinion. Now, criminal defense attorneys can submit proposed voir dire to the judge and say, we would like these questions asked. However, it's the judge's discretion. It's totally their decision about what questions they want to ask. And unfortunately, for the most part, it's hard to show that the judge abused their discretion to get something overturned on appeal. Now, so a judge may not want to ask a set of questions that are really vital to seeing what is necessary to find fair and impartial jurors, or at least pull out the implicit, the unknown bias in those jurors, so the lawyers can have intelligent decision making and exercising their strikes. And so with that being said, the lawyers submit their proposed questions. The judge may or may not ask them. And ultimately at that point, Again, if a motion's made for attorney-conducted voir dire, so basically what that is where the attorneys get involved, ask questions, basically be able to elicit, and there's different ways depending on what state you're in. It's different by state of how they do it and how long it'll take. But there are ways to at least have some attorney-conducted voir dire so we can ensure that a fair and impartial jury is selected. Now, I was recently interviewed by a local news station about this actual very issue related to the Murdaugh trial. And, it's about, you're in a small town, and how are they going to deal with this with there wasn't a motion to change venue. So everybody there knows the Murdaugh name. It's a low kind of, a local community of everyone who knows everyone. And then it's such a high profile case, and how to deal with that. So to contrast it from what a normal murder case would be, a normal murder case would generally have jury selected by, say, noon to 1 o'clock. And that's terrible. It's something that, like I said, zealous advocacy from criminal defense attorneys. We want more voir dire. All right, that's too fast. We need to know more about these potential jurors so we can be intelligent in exercising our strikes. Now, if we have good reason and good information on the arguments to say that this potential juror could not be fair and impartial for whatever reason, we can make a motion to strike for cause, and that won't go against our strikes. Now, criminal defense attorneys in a murder case get 10 strikes to use in that jury selection process. And of course, there's always going to be 12 jurors selected. And then depending on the judge, they may do 2 or even up to 4 alternate jurors in case something happens and jurors are removed. They can move those alternate jurors into that role. Now, with a high profile case like that, they actually allowed for jury questionnaires. That's another thing that if the prosecutors don't object to it and the judge agrees, a lot of times in even a standard murder case, if the defense is willing to pay for it, some judges will allow for jury questionnaires. So in the Murdaugh case, they did jury questionnaires to where the set of series of questions, so you could really figure out what their background is, who these individuals are as a person, so you can make the right decision in exercising your strikes. And so they sent out the jury questionnaires, which I'm sure was incredibly helpful in making that decision, because without those questionnaires, it's just such a limited amount of information, and the law needs to be changed on it. It's something that we're pushing very hard for in the General Assembly, and it's crucial and critical to ensure that a defendant receives a fair trial and has a fair and impartial jury. And so ultimately, there's a million other components to it. There's all these other things. And so if you got any additional questions, anything more specific that I maybe didn't touch on or you would like to know more about, feel free to let me know, and I'd like to do that. But ultimately, jury selection in South Carolina is too fast. We need attorney-conducted voir dire. We need the law changed. And there's just more information that needs to be known by the lawyers before they have to select a jury.